Wesley and Frank, who are both looking very serious down there, come and sit on stage here, and I will introduce you both. I was lucky enough to live through the passage of the National Archives Act of 1986 and its final implementation in 1990, when we saw a deluge of material from government departments come flooding into our building. It was overwhelming, and it took a long time to get to the stage of thinking about sensitive material and its disposition. Data protection had not yet become a big thing, and GDPR was a twinkle in some European eye at that point. I had to encounter these issues when, in 1996, I discovered almost 2,000 files dealing with Irish children adopted in the United States. I had to very quickly learn how to deal with extremely sensitive material while making what I could accessible and bearing in mind the needs of such people, now adults, to have knowledge of their own identity. That has been an issue that has been on my mind ever since, I suppose. These problems are at the heart of archival decision-making, and there are differing views as to how to resolve them. We have two experienced practitioners of these processes with us today to share their knowledge and expertise with us. Wesley Geddis is acting head of records management, cataloguing and access to closed records section at PRONI. Wesley has been working as an archivist for 25 years and has worked in PRONI for over 20 years. During his time there, Wesley worked on the introduction of PRONI's online catalogue and was later responsible for planning and coordinating the transfer of all the archives held by PRONI to the new premises of Titanic Quarter in Belfast, of which we are all very jealous. I mean, you see this fantastic building up there in the Titanic Quarter. Those of us who were in the National Archives when it all started, I'm sure, Mary, those of us who are still there, long to have something as glamorous and beautiful as the Titanic Quarter building. Over the past 13 years, Wesley has been responsible for cataloguing troubles-related collections and for providing access to these sensitive records. He has extensive experience of assisting victims and survivors seeking access to troubles-related information and others directly affected by historical institutional abuse. And I met Wesley as part of a conference that we had in the Royal Irish Academy last year on archives and human rights, where we learned a great deal from him and Joy Carey, his colleagues, about how PRONI is going about accessioning to deal with the records of the religious orders that ran these carceral institutions that still create great difficulty for the affected. He is responsible in assisting in the Truth Recovery Programme to receive and preserve relevant official and private records and training which relate to mother and baby institutions, maritime boundaries, and workplaces in advance of future public inquiry in Northern Ireland. Currently, he's also leading PRONI's engagement with the Independent Commission for Reconciliation and Information Recovery, chaired by Sir Declan Morgan, which aims to support victims and survivors of troubles. That's Wesley, and we'll be hearing from him first. Our second experienced practitioner is Frank Sheridan, who worked in the Department of Foreign Affairs from 1973 to 2014. During that time, he worked in the Washington Embassy from 1977 to 82, the Anglo-Irish Division in 1982 to 83, and the Secretariat of the New Ireland Forum in 1983 to 84. He was Consul General in Chicago from 1994 to 98. He was ambassador to Mozambique from 2005 to 2010, and ambassador to Brazil from 2010 to his retirement in 2014. After his retirement, he worked as a researcher on the John Human America documentary and Seamus Mallon for his famous book memoir. He edited a book by Sir David Goodall on the negotiation of 1985 Anglo-Irish Agreement in 2020. He began work on the release of the Anglo-Irish files in the Department of Foreign Affairs to the National Archives in 2017 and has done so since, including clearing the backlog resulting from change from 30 to 20-year rule in 2018. Since 2023, he's been part of a team at the initiative of the Northern Ireland Secretary of State, organising resources for secondary students and their teachers on the Belfast Good Friday Agreement. Now, I'd like you both to talk to us for about 5 to 10 minutes maximum on the processes you use for making the decisions that you do and the legislation that you have to observe, which is obviously different in Northern Ireland to the Republic. We'll then chat for a while and we'll have time for about 15 minutes of questions from all of you at the end. I expect that we're all going to learn a great deal Congress to Wesley. Right.
So, without further ado, thank you all for listening today. And thank you for the invitation to speak to you today about access to how PRONI deals with access to information or conflict related information at the record office. PRONI is the so PRONI is the official archive for Northern Ireland. We were founded in 1923 after partition. So legislation in 1923 Act, which allows PRONI to receive public records from government as the official transfer, but also records from our private origins. And we have over 10,000 private collections of PRONI, in addition to the public records that come from both the government itself in Northern Ireland and also the local authorities and all other 140 public authorities in Northern Ireland. Now, we all see the legislation at that time said that we were to provide lists and catalogues of material from the PRONI. However, there was no provision for access to right. So that was amended, or 23 was amended in 2000 with the introduction of the Freedom of Information Act, which was then introduced in 2005. So we operate on the UK FOI Act first. Now, what do we hold? So the talk I'm going to say about is what we hold, how we make that available, and the outworkings of that for researchers. So essentially, very quickly, what information is held related to the conflict troubles in Northern Ireland. So of course, we hold the records of Storm government, the cabinets, and all those related functions that were being documented. We also hold then these what are called the service reports. You'll see in here one of them. So in the early days of the troubles, up to the early 70s, every day there was a situation report was being created and fed to the RUC, which then made its way to the executive, detailing in detail what was happening on the ground every day, who was being injured, what incidents were happening across the whole country, extremely detailed. They give you names and addresses of victims or survivors or persons affected. So very useful for researchers. Each day like that might contain 5 pages of information. There could be 10 pages very eventful, very terminology. Then of course, after Stormont is dissolved, the Secretary takes over, and these are reflected in the policy files, the topics, which will be from the perhaps, and many others. So looking at the program today, the other discussions are all documented in our files. The files are titled Recatalogue Material as the regulated file titled don't augment the description purely because of the lack of resource. So the file is titled Large Talks, files House dealt with by PRONI. You don't have the resource today for each of the full descriptions, unfortunately, about it. Then, of course, there are NLO files for NLO Belfast. So again, they're looking at the security situation in Northern Ireland at that time, and they deal with criminal justice, administrative justice in Northern Ireland, the running of prisons, and the instruction and monitoring of internment, to name but a few, and then general policy about how security situations were handled at that time. Throughout the whole period of trouble was actually 1998. They're also available at PRONI. We also then have what we would sort of call the case files related to the troubles, court records, which are vast. So 1966 onwards, the levels of cases, as you will imagine, dramatically increase to around 1,000 a year. Most of which are closure-related cases. So the 70s, 80s are in between. For the appeal, I'm not going to do a whole list of records here all day, but Again, the main ones are obviously the files, PPS records, where investigations were carried out by the PPS to determine whether or not the case could be brought to trial or not. Many of which do not come to trial. If a young person has been committing an offence, will be used justice file by that individual. Set of justice government students as well. And of course, then hospital records to people who were injured, of course, or who then passed away as a result of injuries. They're also kept in PRONI, although not in comprehensive fashion, because all the records still held by the trusts in Northern Ireland. So, how do we deal with to all this information? So, right now, a big gap through the technical information that we hold. Well, we have two ways. One is reactive, and one is a proactive release of information. The reactive way is through, and there's three areas here of legislation: Freedom of Information, UK, 2000, and we receive that certain number of requests a year, of which currently we receive about 120 requests for total heritage cases a year. And we have a huge backlog of requests. Well, we always adapt to the deadline, unfortunately, so we probably all have to be cases. Although there is a section within the FOIA that allows us to refuse a request on the grounds of the cost and time that will take to do that, we probably do not invoke that. We talked with ICO, Commission Commissioner about this, and they accept that position. We would rather release information late than not at all. Invoke that. Equally then, subject access requests from people looking for their own information. Again, that's a total number, and again, unfortunately, a huge number of requests in our backlog of that. Equally then, there's a third method, which is a bespoke arrangement that people who have been directly affected by an incident can apply for information outside FOI. And that's essentially a private release to that individual based upon what they have to worry about. That must relate to incident therapy and related to it. Now we have 30 or 40 groups a year. We have proceeded with about 300 to 400 of those requests over the time since its introduction in 2016. But certainly on the FOIA and data protection, we're talking thousands of patients or requests in the last, say, 10 years. Then, obviously, when we're releasing information to FOIA, it's not compliant. So, anyone can also have information with our legislation. These are the types of exemptions that prohibit the release of information, which we have to then take account of. We're dealing with very sensitive information here. We're dealing in a policy file where it might refer to an individual or a case, right down to the really detailed case files of a court case that may have gone to trial, the person found guilty or innocent, or indeed policy plus files to make graphics or nature. So when working at FOIA requests, we have to be, our position is disclosure as much as possible to assist the applicant. But we must be making sure that we're applying the legislation correctly. And that may sound straightforward, but actually it's very difficult at times doing what to do as well. So the proactive release is different. So the reactive release, responding to requests. Now I have the proactive release, where probably releases files which become historical after their retention period. Now I mentioned the 30-year rule. That exists in what was introduced in 1976. It was 15 years, from 1922 to 76, and then overnight, we're releasing just the 30-year rule. And we have to stand guilty doing that, flying at it, without a warning. So he introduced it in 2012. That was amended with that transition order to 10 to 20 years of work. So over the last 13 years, we've been working to just 10 to 20 years. That was a hiatus during the pandemic. Hence, this year, 2025, is the final release of the 2 years worth of files. So by the end of December this year, we will be in step with the 20-year rule. In a couple of years' time, we're seeing the end of records in terms of the government creating paper records in departments. So we're moving to more digital, so we can watch this space on that with our. So then on the proactive release as well, just to talk about the process for releasing, we receive in PRONI records which have 3 access decisions essentially. They can transfer to us either closed, they transfer fully open, or they transfer with a partial release, which the Department of Transferring Body has recommended. This is obviously sitting under the Section 46 Code of Practice, so it's not something we decide to do, but government departments are obliged to do that. However, they don't transfer everything across. They still retain certain records, and that is down to a resourcing issue. So we know the rights that haven't transferred, and we are more than keen to take the records in, if it should be in an archive service, hopefully viewable, we'll call it, and Catalogue to see what's left, rather than managing a government department where nobody knows they exist. Again, the presumption is openness, and the department must transfer that record with an access decision saying open, closed, partial, reasons given for that. We can challenge that, saying you've been overzealous, you've been conservative, you usually think again or reconsider this. The final decision on the release of information and the acceptance of that recommendation sits with PRONI and ultimately with the minister responsible for PRONI, who is currently going alliance the DEP, but of course they all change as the new one comes. So as I say, that's the recommendations. Hopefully that is still easy to follow. So some of the main things that we have to do with them when we're considering our release of information, whether it be under the proactive or the reactive release, or under key exemptions which occur in these are the issues that we have to face and consider when we are releasing information. Major one is personal information related to living individuals. And again, this is all issues that we have to whether it's their name, address, medical details, their associations, their family, whether this is about to other family members, etc. This is not public knowledge. We care about what we're releasing on this issue here. Then, of course, we have the security of information, the law enforcement. So we're all seeking to assist offenders in any way, or assist first security or last security involved. So of course, we are seeing court records and inquest files. We're looking at will this information be able to use or impact in a future investigation? Will it have a negative impact on security generally? So, for example, weapons details, weapons serial numbers should be prohibited. Explosive devices are restricted. The government can obviously tell people are really wrong, essentially. So that see them to protect names of other human source forms to long term must all be protected. If we try to do that, national security, we will be stuck with the national security division. Everything must be doing that. Then we also move on to our health and safety, a big feature of what we do is qualified exemption. This relates to the health and safety of all the recipients or the person viewing the record. Will they be harmed to a significant degree? So this is not upsetting somebody, oh, well, you want me. is involving substantial distress to the university. So these are in terms of graphic fund. Sorry, that's all. It's a little bit more than me. So again, is that going to be the graphic accounts of an incident? Descriptions contained in the file of a death of an individual. We'll see here. Or equally is photographs of the deceased individual. These are all contained within the scene of the event in one situation. So these are not things that we would see written in the file. We therefore have to include those of the of course, there will be instances there of supergrass trials, again, very you're having to honestly you're investigating yourself. What is happening, what are them, once these things are discussed in media 40 years ago, what long we're going to have to spend time reviewing this information. We do a lot of research to say this is going to re-traumatize, remind you of what to say. So people then go and say, I'm all going up somebody's door, so it's all very carefully done. And of course, this is ongoing for many years. This is called exemption falls away. And of course, then we have a session for long information moments where information was disclosed by a professional or civilian with the caveat that it will not be. So of course, when are very important information here, that are again, people who are looking for information are desperate to know what they find. And the more than I'm not about start of this story exists, we might see that information, whereas they do not. And we end up knowing more about the case than they know. And people want to know what happened, and these artists were students have to be so careful to very things accurately and don't be over-interpreted. Well, it's extremely damaging for people. And of course, then our favorite one is international relations, which is not usually just the policy files within the Central Secretariat files that you're familiar with. So, one issue or terms are territorial waters and water for oil and absolutely. And other free water protected groups. And being respectful and mindful of one another, and to be not just UK with Ireland, but across in other jurisdictions as well. And these are issues that we have faced in the past, and we will presumably face in the future. They are discussed periodically between officials and between ministers, so it's something we have to be mindful of, carefully consider. I should say, when we are releasing things proactively, under the legislation, there is a panel of the sensitivity review group, which meets all the departments meet together along the PRONI, and we go through the redactions for the release that year to agree with the consistent approach, looking back at what was done in the past. So I might thought that things moved on, a sensitive release is either to release or not. We as PRONI will always say release, give us the reasons as to why not. Okay. We prefer to be transparent. So what does this all look like for you, the user, the customers? So we have been transformed by the introduction of our online catalog. I'm not just saying that because I worked on, but it has been transformational for PRONI. This is what we start. So we know that you can search for the words prisoners in this case, and you'll be hit with 1,000 results on the catalogue. So here you have a line here. It is closed to the public, but it says, guess what? There's an open version of this file available, and here's how to find it. So there are many elements therefore of original file which are closed, and these are those elements. Likewise, then goes 60A. That's the open part of the file, which has gone through, in this case, gone through the department profile, it's gone through a sensitivity review with our oversight, if you like, is to agree that recommendation. And likewise, then the customer can deploy more or less in our reading room. Of course, very brief description. Unfortunately, there isn't the time to identify those or putting more detailed, more detailed catalog and trigger spreading what's in that file. Unfortunately, what's something we can look at. Again, another example, this is of the College Dublin file. Detailed against all 4 individuals who were killed at the Ballymurphy shootings in August 1971 will be with that. So we have deliberately kept it quite bland in a way, factual, without referring to the circumstances of these deaths. That allows each person to know, or the relative really will be to know what we will want to refine. Again, there are elements in that file which are closed. With personal data, could be distressing content, presumably. The will be one of those files, which exists. So to protect that, we have a closed version. The original version is always closed in these cases. We then have our open version, which is then viewable by the researcher or the family. This has been the subject of a FOIA request, yes. So that then, just our next slide then is saying, those are the how we make information available. Another aspect of this is our PRONI records on claim. Now that has also been, that's also been wonderful resource that we use in other public services, except the body use as well. We're in partnership with the University of Ulster to make selection of documents available in public via machine portal. You'll see that the figures there are available. It's recognized as one of the leading online resources related to the troubles in Northern Ireland. And I know that the National Archives have also done a partnership with Keane all in what was done with PRONI, so that's ongoing. And we have Brendan Lynn, who's here today, is the researcher responsible for selecting the records that make up the images on Keane every year. It's not really ongoing, and the records for 0203 will be available hopefully early next year. So that, thank you. I should also say this transparency at all has very positive to the researcher. However, the one drawback, just to the final point, is there is an implication. The good for transparency in government, allowing the public to be informed and empowered to know what we hold. However, with that increase in transparency comes a drawback. The drawback is the lack of content in World War I records. People now have an eye to what we would record when me, and my career is still happening in 20 years' time. Records and minutes are being sanitized. None of the detail is there, of course. This is not a problem for me or the owners of the service, but it's something we have to be mindful of, and that was highlighted in our recent release of files where a journalist can say it was the most boring release they've ever seen, given the content. So we had to sort of go, oh, well, we didn't create it. It was a good little release, but that's the work we live in, unfortunately, today. So I thank you. So I'll take questions of course. So thank you.
My career and so on. There is an importance to it in the sense that both my career in the Department of Foreign Affairs dealing for 13 years, sometimes peripherally, sometimes more centrally, with Anglo-Irish affairs, with effectively the troubles in Northern Ireland, together with over 10 years since retirement, of being involved in research, what we can do with Northern Ireland as well, means that my approach to the release of files to the archives and so on is personalised rather than systemic or programmatic, and doesn't, I would argue, offer itself as it were as something that would work for others. One other sort of unusual dimension to my involvement in this area is that because of my career in the Department of Foreign Affairs, I know virtually every contributor to the files. And even worse, I know their handwriting. And it means that there is nothing, in a sense, that is hidden from me. I'd like to scribble in pencil, if I think it's needed, the name of the person who has given me this illegible scribble at the end of an important report. Anyway, turning to what governs the release of material, as Catriona said, the National Archives in Ireland is governed by two pieces of legislation, the National Archives Act of '86 and the National Archives Amendment Act of 2018. The first is a very lengthy piece of legislation, and I can say that because I've read it in detail in preparation for this talk, and the person who wrote it has a great flair for legal English and for making things as difficult to understand as possible. But anyway, it contains a significant amount. There's about 100 pages, I think, in the original act. And then the second act is to allow for the release after 20 years of Anglo-Irish material. The second act provided the opportunity to provide a guide in relation to GDPR, sort of the whole area of data protection rights. And it provides that material should be withheld if it's released which jeopardizes international relations or infringe rights. And specifically what it states is that it would be a thing to be withheld if they're contrary to the public interest, if they would constitute a breach of statutory duty or a breach of good faith on the ground that they contain information supplied in confidence, or would or might cause distress or danger to living persons on the ground that they contain information about individuals, or would or might be likely to lead to an action for damages for defamation. Thus, as I saw my task, as I did, of trying to ensure that to the extent possible, the full story of these events was released, there were challenges in dealing with these constraints and GDPR issues. And it became clear to me that GDPR and wider stringencies were diminished if the issues were at the time or since in the public domain. They were also reduced, I concluded, if the informant on the subject or the person about whom the report is written had passed away. And lastly, if reasonably and with evidence, one could conclude that the matter at hand no longer had currency or relevance. And to assess issues against these constraints, I put all the files warranting examination to one side every 10 days or so, trying to examine them. And in that examination, I searched all relevant names, titles, stories, all online and in the main newspapers in the Republic and in Northern Ireland. Something worth noting is that many times the publication which had highlighted the issue was on Public, the organ of Sinn Féin. On deaths, I added to the favourites on my laptop the following: RIP.ie, passedaway.com, funeraltimes.com, and occasionally I would develop the death notices in local, usually weekly newspapers. I think RIP will no longer be available. They're going to start charging for it, but at the same time, it was hugely useful in basically confirming if someone was wrong, or more importantly, not. One group of people that it was important to protect were individuals who, under the 1985 agreement, had made complaints, often through the Anglo-Irish Secretariat in Belfast, regarding the security forces. They, and frequently those about whom they had complained, especially if they'd been in the RUC or UDR, might actually know each other, and in some cases even live in the same town. Websites which were hugely useful in checking if the informant was still at the same address were the online landline telephone directories, which I discovered several years ago were still operational and very often kept completely up to date. Two other sources that I would also check to see if issues were relevant, or three other sources, were the UK Archives and Kew online and the online Margaret Thatcher Foundation. And one other one, which I found very useful, was the Dictionary of Irish Biography. This process did diminish very significantly the number of files and reports withheld for a review 5 years later. And in addition to the protection of the GDPR rights of individuals and also ensuring the information given in confidence and probably still relevant were not inadvertently released, there was one other important task. And that was bringing to public attention the intricate processes leading to progress in resolving a conflict with its roots stretching back over centuries. This involved the work of many people over decades, and the files released each year hold up one mirror, one of a number, to their work. And to assist with this task of promoting wide attention for the newly released archival material, the Irish National Archives has the innovative approach of giving the media access to the files marked for release about a week or two before the actual release. And during the last 3 days or so of the year, 2 of the Irish national newspapers provide 2 pages of coverage, and the National Television Service, RTE, also covers the release, and in addition to the stories carried in news bulletins, carries many more on its website. A number of reputable journalists are involved. For example, Dr. John Bowman, who hosted the Questions and Answers political analysis program in RTE for 21 years, covers the release for the Irish Times. And David McCullough, the newspaper and biographer of politicians Eamon de Valera and John A. Costello, covers the release for RTE. And inevitably, as the year's end approaches, I do get approaches from journalists like these to know if there are any items of particular interest to which I would like to draw their attention. And to that end, and before the approaches are made, my reading of the files keeps their need in mind, and I frequently tag files containing material of interest to them with a blue dot saying reviewers may wish to see. Examples of the type of stories I might highlight include a report from our ambassador in London about an interview he gave on Irish policy on Northern Ireland to a Current Affairs television programme, I think it was ITN. And he had discovered while there that another interview on the same programme was with a commentator who asserted that there had been a significant involvement of MI5 in the Republic, and that it involved active engagement with the Irish police force, the Gardaí. There was a sense from the ambassador's well-written report that the source of the story might pass for what had been known in Trump days as a conspiracy theorist. I queried with the ambassador, then a retired former senior official, if he thought the report might be brought to the attention of reviewers as a story of colour, and he agreed. Another story with more recent relevance was a report from our press officer about a mission in the EU in Brussels, and a lunch he had with none other than Boris Johnson. Then, I think, a report with the Daily Telegraph. And at the time I was reading it, Boris's term as PM had ended. And obviously, he was still a person of interest. The report, dating, I think, from the late 1980s, showed, with regard to the EU, tremendous consistency with his later views on Brexit. And the EU Commission came in for a lot of criticism. Anyway, again, having cleared the matter with the senior officer, I marked the report for the attention of reviewers on the ground that it might raise interest in these releases. One has to be careful, obviously, in this area. One, I was considering release at one stage or on a conversation with a retired politician, British politician. I was wary about it and I held back. And luckily, because he has come to significant prominence yet again, I'm not going to get into it, but he is looking for a diplomatic position abroad. Anyway, sorry, that's in relation now. Another challenge that I face, and that all will deal with, dealing with archival material, is how to deal with electronic records. My first encounter with this challenge was when I opened an archive file and found that in addition to paper records, it had a number of very old 5¼ inch floppy disks, the original sort of disks. And I phoned the people dealing with IT matters in the department. Unsurprisingly, found that there was no machinery anywhere in the department that could be used to read them. But they were nothing if not innovative, and they purchased the necessary technology on eBay. To my deep disappointment, all the floppies showed what we call organograms. There were diagrams of the various personnel assigned to the divisions in the Department of Foreign Affairs. However, they are a portent of what is to come, and the challenge is to ensure that we find ways to capture all records and ensure reviewers too can access them And both those archiving material and those using them can use the electronic inventors, which it provides. I'm not going to go on much longer. I was going to give some of the background, but I think that Tina has captured all of that in her introduction. And like Wesley, I'll be glad to answer questions we have. Thank you.
Wesley, a question that arises for me from that very full presentation that you made to us, and thank you for it, is how do you decide on an access date for closed records? You mentioned one, I think, on one of the slides, which said something was closed in 2067, I can't remember what it was, but do you have a protocol for deciding when eventually these records will be made available?
Most of the recommendations are to do with personal data. So we're trying to establish the date of birth or age of the youngest person. It's very difficult, but hopefully they're looking at something very specific on that particular file that has told us that that person was born in 1966. The way we operate is 100 years old to at least confirm that the person has passed away. Obviously, people are living longer than that, but at the moment, that's the position. We do have slightly longer caveats for those that are related, well, not trouble related, but more related to sexual offences. There's longer, more than 100 years old. But yes, most of those extended terms are for to do with the date of birth, age of the person who got involved in that case. So don't have to be victim survivor, to be anybody involved. As long as they're all deceased, we go with that because as an initial stage. We can also give us that down the line. The archivists are working currently in the 2060s. Well, if PRONI still exists in that form, then we'll look at that again. Walk forward to this on all.
So it's a fluid moving line.
Yes.
Okay. I mean, obviously Northern Ireland is an exceptional case because of the numbers of records that you have dealing with the conflict per se. You obviously make special cases for other things too. But it is possible, I assume, for people who are in closed files to be able to access their own information. Is that correct?
Yes, so they
They can do that under FOI?
know under the Data Protection Act.
Under TP.
They can submit 2018, they can submit their request confirming who they are. There's various documentation required before we go there and not confirm that I won't people until they prove that they are who they say they are. Because we will get serious requests in and you confirm the relevant checks, due diligence, and then before the check, if you have more information, then that is then released with just their information. And we have to be quite restrictive on what was their information. So it's discussing third parties.
That was the next question.
That's all we use. So they're getting quite a limited release, given the content that they're looking at and what's contained within. So most of these records are due to troubles, or time in care, or time in facility where they're committed a crime, or there's abuse, or they're doing a statement. So out to other people who may not wish that to be because then they once you release that to that person, give your information, that person can put that online, they do it like it's their information. So be careful about not reaching other people's privacy. Sure.
Amazing. It's incredibly difficult to manage things like that when people want context as well as bare personal information. But of course, you have to be aware of third parties and how that works. You mentioned the, oh yeah, the other question.
The person was deceased, most of them not heard.
Right,
And
and
the
they
other
dealt
party
with
is.
Yeah. And the family version to that too, what you said. You, in your catalogues, mention the names of people who appear on closed files, am I correct? You have to give an example there of prisoners' files.
Yes,
Because four names were there in the catalogue.
They were then like when there was deceased individuals.
Right.
So
Deceased.
it was an individual, request file, yes. They can be publicly released so that anybody looking for information about an individual will know of the whole inquest file or a court file, especially about that individual. They don't have to ask PRONI and they'd be embarrassed. Do you have this file? No, they're empowered to look on the Catalogue themselves and see what they hold, and then do that something.
This is very important because, of course, if you keep catalogue information from people, they may not know the files exist that have direct relevance to them. And I suppose the two big issues that we're talking about here are, in terms of difficult sensitive records, first of all, they matter to the people who are mentioned in those records. And secondly, they go to general scholarship. And eventually, after however long time passes, these records will be fully available to scholars to analyse them in the context of the overall issue of the troubles themselves. I have a ton of questions there. I'm going to keep it myself for a short time. It's great that Wesley's going to share his PowerPoint with all of you, and I hope Frank might be willing to share his paper too, so we can all take away something from this. Frank, you're a fascinating case because you know the people in the files. So, I mean, I won't ask you to tell me any fun stories about discovering things about who you know before, but I'm sure there are many examples of that. You also do a huge amount of research to try to aid release of the material. Your bias is towards being as making the material as accessible as possible, which in my experience has always been the case with the Department of Foreign Affairs. They were far and away the most liberal department who transferred records to the National Archives in 1986. Is that very, it sounded time consuming in terms of what you were putting into this, looking for records of deaths and so on, so that you would be constrained by data protection, all kinds of contextual information. But you seem to get the work done nonetheless. I mean, obviously,
Most of it was driven by annoyance. Because when I was back to Trinity to do the Master's in History, I was focusing on the UN reform and what it might have achieved in terms of, photography, British, the SEO reacted to it, and the NIO in Northern Ireland. And I found repeatedly, went to Northern Ireland, went to Kew and so on, material was withheld. And I knew from other sources, and especially because I've been confidentially given a copy of the memoir that was David Goodall on the subsequent environment agreement in 1985. Basically what was or should be in the files, it was not available. And I found it frustrating and annoying. And at the same time as I was doing this research, I had been asked to do research on John Hume in America on building the Irish lobby to help one in Northern Ireland. And I was finding on the Irish side, yes, virtually all of the material was there. But I did find the British side very interesting. I found a file on his work as Minister for Commerce after Sunday, when he did a tour of Northern Ireland. It was fulsome. When he came to Northern Ireland, there were a lot of restrictions. And that element of it, they were applying to the need to be restrictions and so on. And I paid fair bit of attention thereafter to GDPR and to see how can I work my way around these sort of blockages to ensure the full story gets out and that people are not working on the basis of partial insights into it.
We absolutely commend that. I mean, you go above and beyond the call of duty in terms of trying as hard as you can to make the records available. And so far, the sky hasn't fallen on our heads because DFA has been liberal in its approach to releasing records. Now, I'm conscious that lunch will be coming up very, very soon, and I'm sure you're hungry. So I'm going to move this out to the broader room now. and ask some questions. This lady down here
Thanks
first.
so much. Susie Egan, Audience Project. I just wanted to ask Wesley, this is based on an example that I came across as a researcher a few years ago, but how does PRONI decide to reclose files? And I think maybe what might that mean for, other archives? And like the example I'm thinking of are Home Affairs files from the 40s that were opened to certain historians and have been published from, and then are completely reclosed again. And I just wonder, what's the process there? Like, what has to happen for things to be reclosed, and when are they able to be reprint?
I haven't seen much in relation to fines reclosed. What I did see when I began this work was a very conservative approach to the release of fines, and a lot of material withheld. And when I was doing, one of the things that I had to look at were fines that had been withheld 5 years previously. And I would look at them again and taking this other approach and checking if the individual was alive or dead, checking if the story was still topical, or if there were any particular reason for withholding it further, I was able to secure the release of quite a number of files. On the pretext that an individual had been named and who had given something in confidence, but nobody checked if he or she was still around. So when one had done that and discovered that they weren't, then obviously there was no particular reason anymore to withhold the file.
Yeah. I suppose it's a resource thing as well, like the ability to do that rechecking.
Yeah, well, there is, I think, and Andrew can answer better, in the British Archive, there is an ability to appeal. And I recall looking for a file, and I can't recall what it was, and discovering that under freedom of information, it had been withheld. And I wrote inquiring about it, and my inquiry got the file released. That, when they re-examined it, whatever the initial reason for withholding it was no longer relevant. But there are, I think, in both cases, a right to appeal, to go back and ask, is the reason for withholding this file still valid? And, can secure its release as well.
And Wesley, of course, outlined for us what the process is in the north.
Yeah.
The final arbiter is the minister in charge of PRONI. That means you, I presume, because what the minister knows. Questions if they change something. That's democracy, we're in favor of it. Chat down at that.
Well, we have been on day. Watching your presentation, Wesley obviously centers on government generated material, state the record of the state and the likewise, right? We would hold quite a number of items which are not generated by the state, but a lot of those things, like I'm thinking as an example, an organisation like the Association for Legal Justice, which interviewed people with there in 1970. What rules can apply to such organisations or can be applied to such organisations? Obviously, they're not going through the protocols of the state in terms of signing upon release, but outside of sensitivity in terms of named people in those documents or the exercise of time that's gone through there to determine whether or not the right or not. What other obstacles might be going in the way of making those things generally accessible?
Well, again, I suppose personal data, living individuals that was discussed there, mentioned, and presumably information provided in confidence by the people approaching that organisation. Is there any information around when they were bringing that information forward to that body? Was there a duty of confidentiality? And by making it available, are you going to cause substantial or significant distress to the families concerned? Information might be in public. They were coming forward. They may have, say they were involved in or arrested or assaulted in some way. They brought the case to that body. Will that be brought forward in a private capacity to let them know what happened? Then suddenly making that available. Well, all of they may want to forget. Some family members will make it public, or will say that's not private. Discussing that. So these are your things to consider. But equally, it's ultimately to discuss that with your depositor. private deposit to say, these are our carefully considered options for you to look at. We recommend this so that you're making some information available rather than nothing or all of it. So it will be a large piece of work to that available for researchers, but again, it's really up to the depositor and yourselves to come to that agreement. Taking into account those various elements of distress, confidentiality, personal data, and that there is no one voice for a family. We have differences of opinion and family fallouts and disagreements. So, who speaks for the family is one thing, or the person who's deposited, and that's very difficult to accommodate. We have known where you have siblings, and one person wants to do everything, one person wants to do nothing, and they get very agitated when they'll say to stop the sister, and it's all very messy. So we have been with that too, even in the States, where parents as well. So that that's a helpful that answered part of your question.
Yeah, I'm thinking that these people would voluntarily provide the information, and it was about,
Yes,
it wasn't for they're not providing it to the state, they're providing it to an organisation which
Yes.
they are confident or will be used for a particular purpose, creates parallel or narrative. I take on board what you say, and family is important, but at what point do you work family, that can you, for instance, hold something back because a grandchild doesn't want
I think because of the time, yes, things will diminish their sensitivity. We would try and contact depositors to say if we're going to make this publicly available now, rather than suddenly get lands on a public platform. The family are the last to know about, and they're hearing from a third party or to see that online. So it may be worthwhile doing that, or at least making attempts to contact people, say it will be made available. It's tricky, I'm afraid. But there's no set rule, but equally you do have to comply with even a private organisation with your data protection and not pretty much. You might have a sanitised or a pseudonymised name or redaction there, so you know it's a person, but you're not necessarily know who it is or the precise location for that family. So there are ways to get around it. The essence of what they're looking is still available, but you're not saying exactly who it was that provided that information.
I maybe add something to the Irish files that you were approaching 1998. There was a very significant increase in the number of files dealing with prisoners because it's coming up for consideration for a mass release if there is an agreement. But there are considerations you have to take into account in terms of what kind of release, what kind. If there's any reference to families or family details, that's not relevant to the prisoner. It's not something that should be in the public domain. So that would be fine. Similarly, any reference to mental or physical health, that would be something told right about. But anything other than that, even if it is the conviction has been in the public domain and details have been given, so that would not be relevant to the extent of
It's very granular, isn't it, this? Because you're having to, and I presume more and more, you're looking at redacting certain files, your partial release files, for example, that you can get out there stuff that is not subject to any of the many restrictions that you were obliged to about. Certainly have to certain things that you personal material closed. We're almost at lunch, actually, we are at lunchtime. Ian is looking at me with eyebrows raised, so I think we probably better hold there. There's so much to discuss here. I'm sure we have questions going on for some time. But for the moment, could you please both thank Wesley Geddis and thank Sheridan.